5, 4, 3, 2, 1. In view of the above statement of evidence of PW3 and PW4, whose evidence is important for the prosecution to prove the chain of events as per its case, the statement of evidence of the aforesaid witnesses has seriously affected the prosecution case. Therefore, the courts below could not have, by any stretch of imagination, on the basis of the evidence on record, held that the appellant is guilty of committing the offense under section 376 IPC. Further, according to the prosecutrix, PW3, who is alleged to have rescued her from the place of occurrence of offense, has clearly stated in his evidence that he does not know anything about the incident. In his statement, thereby, he does not support the version of the prosecution. The High Court has erroneously accepted the finding of the trial court that the appellant has not been prejudiced for non-examination of the doctor for the reason that she was working as a nurse in the private hospital of PW4, and being a nurse, she knew that the information on commission of rape is grave in nature, and she would not have hesitated in giving the information to the police if the occurrence was true. Further, the finding of the courts below that non-examination of the IO by the prosecution, who was conducted the investigation in this case, has not caused prejudice to the case of the appellant, since the prosecution witnesses were unfavorable to the prosecution, who were either examined or declared hostile by the prosecution, which reasoning is wholly untenable in law. Therefore, the finding and reasons recorded by both the trial court as well as the High Court regarding non-examination of the above said two witnesses in the case has not prejudiced the case of the appellant is totally an erroneous approach of the courts below. For this reason also, we have to hold that the findings and reasons recorded in the impugned judgment, criminal appeal number 58 of 1998, decided on 14/11/2006, that the trial court was justified in holding that the prosecution has proved the charge against the appellant and that he has committed the offense on the prosecutrix is totally erroneous, and the same is wholly unsustainable in law. The trial court as well as the High Court should have appreciated the evidence on the record with regard to delay and not giving proper explanation regarding delay of 11 days in filing FIR by the prosecutrix and non-examination of the complainant witnesses with the doctor and the IO, which has not only caused prejudice to the case of the appellant but also the case of prosecution, has created reasonable doubt in the mind of this court. Therefore, the benefit of doubt must inure to the appellant. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.
Thank you.